Most companies assume debt recovery means court. But in Vietnam, many commercial debts are resolved faster, and at lower cost, through negotiation. Not casual conversations, but skilled, legally informed, culturally aware negotiation that is backed by evidence and a credible escalation plan. In this video, we explain why negotiation works, how to structure it professionally, and how LTS law helps foreign clients recover debts without turning every dispute into a courtroom battle. In many Vietnam commercial settings, counterparties prefer private settlement over formal disputes. Reputation, business continuity, and long-term relationships can matter significantly. A lawsuit may push the debtor into pure defense mode, while structured negotiation creates a path to compliance, without triggering unnecessary resistance. When negotiation is handled professionally, it can protect relationships and still deliver payment outcomes, because it offers a controlled solution rather than a public conflict. Successful negotiation begins before the first call. At LTS Law, we start with 3 foundations. 1. Contract and evidence review: what is owed, why, and what proof supports it. 2. Legal leverage mapping: which clauses and legal remedies matter, and what the realistic escalation routes are, arbitration or court, depending on the contract. 3. A negotiation strategy file: clear objectives, settlement boundaries, and a timeline. When you begin with facts, law, and a plan, the power dynamic shifts immediately, without raising your voice. A common failure is negotiating with people who cannot decide. Is the counterparty's speaker the legal representative, the owner, the finance controller, or a middle manager buying time? We assess the debtor's structure and make sure key discussions involve decision makers. That is not about being aggressive. It is about being efficient. When the right person is at the table, you reduce delay and convert excuses into commitments. We do not ask to talk. We propose a structured sequence: written notice, call, meeting. Each step is documented in a way that can support the record if escalation becomes necessary. We use precise contractual language: breach, outstanding balance, cure period, and applicable remedies, so the debtor understands the seriousness and the timeline. At the same time, we manage tone carefully: firm, professional, and solution-focused. In Vietnam, the right tone keeps doors open, and keeps negotiation moving. Negotiation is most effective when you offer clear options. Instead of pay now or else, propose structured outcomes such as a staged payment plan with defined dates, security enhancements where feasible, deposit top-up, guarantee, or other agreed assurance, or a settlement discount where commercially acceptable and properly documented. Many debtors delay because they fear consequences or lack a workable path to comply. Options create a clear exit route, and when options are written and time-bound, they turn hesitation into action. A foreign distributor faced a substantial overdue balance from a Vietnam-based buyer. The buyer did not deny the debt, but delayed repeatedly due to internal cash flow issues. LTS Law led a structured negotiation process: formal notice backed by documents, a meeting with decision makers, and a staged repayment plan documented in writing. A significant portion was paid early, and the remainder followed under the agreed schedule. Details adjusted for confidentiality. The outcome was achieved without a hearing, because the negotiation was controlled, evidence-driven, and time-bound. Not every debtor will cooperate. If the debtor avoids meetings, gives vague replies, keeps shifting responsibility, or shows evasion signals, negotiation becomes a stalling tactic. The key is to recognize this early and pivot. When bad faith signs appear, the right next step is typically a stronger formal demand letter and preparation for arbitration or court, based on the contract and enforceability goals. Many companies leave collections to sales or finance teams. That often leads to weak negotiation: emotional, informal, inconsistent, and poorly documented. In Vietnam commercial disputes, negotiation should be conducted with pre-litigation discipline, clear records, controlled language, and structured commitments. That is why LTS law leads these conversations with a lawyer's discipline and a negotiator's finesse, so you protect your position while pursuing settlement. If your company is facing delayed payments or commercial debt in Vietnam, do not rush into court, but do not drift either. Let LTS law design and lead a negotiation strategy tailored to your contract, your leverage, and your business objectives. Visit lts.com.vn to schedule a case review. Because in Vietnam, the right negotiation, done professionally and at the right time, can often resolve payment faster than court proceedings.